I think we'll get started and people can kind of make their way. So, hi everyone, I'm Supipi. I am delighted to be speaking with you today on the topic of contractors versus employees. So, this has almost always been a bit of a hot topic in the employment law sector. But recently we've had a couple of High Court cases that have made this all the more topical. So when it comes to engaging contractors, it's really important to get it right because there can be some significant legal exposure. So let me get started. So what we will be covering today, we'll be talking about building your team. I'll run through a little bit about Sham Contracting. We will do a very brief overview of the two High Court cases that have come to play recently. So that's personnel contracting and JAMSEC. We'll run through the outcome of those cases and what that kind of means for us when we're drafting contractors agreements, the key characteristics of employees versus contractors, and of course, the golden question, what to include in a contractor's agreement. Before we get started, a little bit about us. We are a commercial law firm that specializes in what we've coined as retail law. So that means we deal with all types of businesses, both small and large, on all areas that they may need specialized legal advice on. So what we found is that our clients come to us as a sort of jack of all trades law firm because we can, for example, not only help them set up their business, but we can also draft their shareholders agreements, manage their retail lease, of course, draft their employment contracts, and lodge their trademarks, for example. So if you have any questions about your business, feel free to send us an email. So as a starting point, we really want to hammer down into what the distinction is between a contractor and employee and why that distinction is so important. So the Fair Work Act covers off an abundance of rights and obligations that may apply to an employee's employment, and these minimum obligations that as an employer you have to provide to these employees. So what happens when this mischaracterization happens? So when you mischaracterize an employee as a contractor is that you risk this legal exposure because if you think about an employee and all of those entitlements that they have under the Fair Work Act, so you're thinking annual leave, personal leave, if a modern award applies, there are a lot of other things that might apply to that employee, and you've mischaracterized them as a contractor so that those entitlements have not been paid. Depending on the length of that employment relationship, so say that that person has been employed by your business for 5 years, then that can add up to be thousands and thousands of dollars. And the really concerning part about this is that this will only usually pop up at the end of that working relationship. So it's only at the end when the employer is then hit with an underpayments claim, a claim for non-payment of employment entitlements, or breaches of the Sham Contracting provisions in the Fair Work Act, that this kind of becomes a consideration point. And what we want to avoid is that happening. We want that to be at the front of mind at the commencement of any sort of employment relationship, which is a great segue into this. So the best time to really determine how your team will be structured and what the legal obligations will be for each type of team member will be at that very onset of the relationship. So when you're deciding to put that job advertisement out there, when you're deciding what type of team members you want, you should have already had this discussion and determined what type of role it is that you're actually looking for. So whether it be an employee, a contractor, a casual worker, whatever your team is structured as, that discussion and those consideration factors should be done at the very beginning, before that advertisement ever gets put out. So in our conversation today, of course, we will only be focused on that distinction between employees and contractors. But I want to flag that casual employees are also a very murky area. that has faced a lot of scrutiny over the years and also more recently. And it's a very easy category to misclassify. It often gets misclassified. So when you are hiring casual employees, it's also something to keep in mind that employee has its own sort of set of criteria in order for them to be classified as a casual employee under the Fair Work Act and under common law. And that can be a little bit tricky. So it's important to keep that in mind. So where it also gets tricky is that the Fair Work Act, unfortunately, doesn't define what employment is. It's really left to the common law. So it's been argued that the common law tests that distinguish employment relationships from contractor relationships are a bit uncertain and they're a bit difficult to apply. So what I hope to do is to summarize some of those key areas for you today, so you can walk away with a little bit of a better understanding of what factors you need to consider when characterizing your workers. And that can be in terms of how the employment contracts are drafted or the contractor agreements are drafted, and that point that I made earlier where you're deciding what type of worker you want from the very beginning of that employment relationship. So the reason why that's important is that we want to avoid breaching the sham contracting provisions of the Fair Work Act. So sham contracting is where you've got an employee and they've been incorrectly classified as an independent contractor. So the new High Court decisions help us to kind of clarify this distinction so that you're able to make sure that your contractors' agreements do what they're intending to do. But having said that, if a contractor's engagement is entirely inappropriate for that particular type of worker, and you kind of embark on that process of classifying them as such anyway, it will be seen as a sham. And the contractor provisions in your employment contract or your contractor's agreement won't apply because it will be seen as the two parties, so you and that contractor, are disguising what is in effect an employment relationship or employment arrangement. So this is a situation where you really need to make the right choice regarding the type of employment you're engaging based on what you need from the person providing that labor. So sham contracting at its core is a subset of an underpayments claim. So it's a situation where the business is saying that the relationship is business to business, and the employee is saying, hey, I was miscategorized, and therefore I'm entitled to all of these employee entitlements. And usually they can make a claim for one or all of these entitlements here that I've listed. So things like superannuation, annual leave, personal leave, long service leave, all things that kind of come into play if an employee has been mischaracterized. And in the end, as I discussed earlier, this can end up being a really big claim because if it's been a multiple year relationship, for example, and there's been no payment of any of these entitlements, it can really add up. And that's why it's important to kind of get that right from the very beginning. So I thought it would be useful to run through the previous approach that was used by the courts so that we can kind of see where the confusion came from. So the previous approach that we've been using up until recently was the multi-factorial approach and similar tests, which kind of required this evaluative judgment of the working arrangement based on what they called the totality of the relationship, which included the conduct during the employment, not just the contract itself. So this is where we would apply a range of factors, a range of indicia to the relationship to decide whether the team members' interaction with the business was more or less like a contractor's arrangement or more or less like an employment arrangement. So we would kind of tick off these criteria and see, does this sound more like an employee or does this sound more like a contractor? The law then required you to consider whether, as a whole, the worker was providing their services as part of the business of the principal or whether they're providing their services on an arm's length basis as part of the services of their own business. So it's really about that distinction between whose priorities are the contractor working for. Are they working on behalf of their own business and kind of furthering their own business, or are they working as an employee furthering their employer's business? So the difficulty with this kind of test was that it was pretty unclear what weight we want to give to each criteria. It was also pretty subjective. It depended on the person making the assessment. So as you can see here, some of the criteria that was considered was control. So control as to how the work would be performed, where, when, all of those factors. And usually a contractor has a lot more discretion about when they perform the work, how they perform the work. It's really about the end result when it comes to a contractor. And when it comes to an employee, you really don't have a lot of control. As an employee, you do what you're told, and you're really under the guidance of managers and staff. So that's a key thing that was considered. The terms of the contract also came into play, but it was part of the mix of all of these criteria. The method of remuneration, so who was invoicing who, provision of equipment. So did the contractor bring in their own equipment or were they supplied equipment? The obligation to work, the hours of work and leave. So were they working 9 to 5, 38 hours a week, or were they working towards an end result and there was no cap on the number of hours that they were working? The ability to delegate and perform work for others. Those two are pretty big ones as well. So in a contractor arrangement, it's quite typical to see that they can subcontract or they can delegate their responsibilities to other employees within the contractor's business, or they can subcontract with the permission of the principal. And they're usually able to work for other people at the same time. So they're not usually solely working for one business. They're usually working for multiple people at the same time. So those are all criteria that are weighed against each other to see whether or not the relationship is more like a contractor's arrangement or more like an employment relationship. But as you can see, that can be quite confusing, especially when it's quite subjective. So this quote, I think, it's from a case that we're going to discuss in a little bit. And I think it kind of summarized that criticism of the multifactorial approach well. Where it must be undertaken, the multifactorial assessment should not proceed as if the court is running down items on a checklist in order to determine the balance of ticks and crosses, as the factors are not all of equal weight in the characterization of the relationship. So what this is telling us is that there is a need to look at the entire situation, and saying that there's, for example, 7 ticks on one side and 10 ticks on the other side, and so the relationship skews more towards an employee than a contractor, for example, really isn't sufficient. So what we should be doing is looking at what the parties were actually contracted to do. And we've got these two people who are looking to establish a particular type of relationship and formalize that relationship in writing in the contract. It seems pretty important to look at that contract, because that's what the parties actually signed up for, and that's what they were intending to do when they created the relationship. So after years of all of this ambiguity and everything that happened with the multifactorial approach, we've got 2 new cases that came to the High Court. So that was personnel contracting and the case of JAMSEC. So we'll run through these cases in a little bit more detail in the upcoming slides, but very quickly, in personnel contracting, the High Court held that this 22-year-old labourer who was engaged as an independent contractor was actually an employee of the company. And in JAMSEC, they were actually correctly classified as a contractor. So this gives us a very interesting insight into what circumstances would classify workers as employees rather than contractors. So, first case to discuss. I won't bore you with all of the nitty-gritty details of the case, but a quick summary will help. So, the Personal Contracting was a labour hire company that was trading under the name Construct, and McCourt was the worker. He was an unskilled backpacker who was on a holiday visa. He had limited work experience, and he was just looking for money at that stage. It was an ODCO style arrangement, so he was assigned to work on construction sites that were operated by a client of Construct, Hanson. There was no relationship, there's no contract between Hanson and McCourt. The contract was between McCourt and Personnel Contracting. So it was a very trilateral relationship. In the contract, in both contracts, he was listed as an independent contractor. But despite the way that they had categorized the relationship, the terms within the actual contract themselves were actually not like a traditional contractor relationship. So, for example, it required McCourt to attend the host employer's site at very specific nominated times, supply labor, and Personal Contracting had the right to control when he would work, where he would work, how he would work. He didn't really have a lot of discretion in his role as a contractor, which it's not very typical of a contractor relationship. He was supplied with all of his equipment. I think there was one piece of equipment that he brought, but most of the equipment that was necessary to perform his services was supplied to him. He had a very regular pattern of work. He had very regular commencement and finishing times, and he was always under the supervision and direction of the host employer. So those are all things that the courts would consider in determining whether or not, when the relationship ended and he was claiming that he had been miscategorized as a contractor, whether or not that was true. So the courts actually originally applied the Multi-Factorial Test. So this means that they were considering the post-contractual conduct of the parties alongside the terms of the contract itself, and they were looking at this control element of the trilateral relationship. The fact that he didn't conduct his own business was something that they also considered. So when you hear that, scenario, it doesn't really sound like he's running his own business. It sounds very much like he's at the whim of Personnel Contracting. So that was something that was considered. And the courts were deciding the weight to be given to the contractual descriptor they had put as being a contractor. So something that they were considering how much weight to give to the fact that the contract actually called him a contractor. So when it got to the High Court, the majority found that the terms of the parties' relationship were quite comprehensive. So in the actual contract itself, it was quite comprehensive. And where it was quite comprehensive in a written contract, the courts found that the legal rights and obligations in the contract should really be decisive in determining the character of the relationship. So where there were some exceptions that the court specified, so they were saying, insofar as the contract hadn't been challenged on validity on the basis that it was actually a sham or varied or subject of other sort of claims, the multi-factorial test and that criteria that we went through earlier, so things such as, for example, control, delegation, the provision of equipment, even taxation, all of that should only be considered within the rights and duties that were first established by the contract itself. So the High Court really was looking at the terms of the contract rather than looking beyond the contract to what the parties were actually doing. So the High Court also made it very clear that the labels that were placed on the relationship by the parties were not really relevant. It was really about the substance of those rights and obligations within the terms of the contract that are determinative. So whether personal contracting or Hansen, whatever they had in their employment contracts as being the descriptor of the relationship as a contractor wasn't really that relevant. And so it was like, in effect, when we discuss this, in effect, what's happened is that it's been an employee-employer relationship that the terms of the contract have created, and that's what was really considered. Okay, next case that I will give a very quick summary about. So this was Jamsek. That was a second High Court case that was very important. So Jamsek and Whitby were two employees that worked as truck drivers for ZG for nearly 40 years. So from 1977 to 85, they worked as employees. They requested a pay rise, and ZG offered for them to become contractors, which would involve this whole process of them buying their own trucks. If this opportunity wasn't accepted, ZG said that they couldn't guarantee that they would have a driver's job going forward. So that sounds very much like an unequal bargaining position here, but that's something to keep in mind. So from 1986, Jamsek and Whitby set up partnerships with their wives and signed independent contractors agreements between ZG and the partnerships that they had created. The terms of the independent contractor agreement reflected a very traditional principal-contractor relationship. And from 1986, Jamsek and Whitby supplied their own trucks and worked as owner-drivers. So they were drivers and they were responsible for the maintenance and other costs of preparing the trucks. There was also occasional replacement of parts in the vehicles and alternative vehicles that they had to bring into the mix, and that was all at their own cost. Jamsek and Whitby were required to work for ZG for 5 days a week, 9 hours a day. They provided the invoices to ZG to be paid, and those invoices were paid to the partnerships and declared as partnership income to be divided between the partners and their wives. So the drivers brought a claim based on the premise that they were actually employees and they had been misclassified. So originally, the full federal court decided in the drivers' favour, and they had considered the totality of the circumstances and the unequal bargaining power at the time the contract was entered into, and of course the conduct of the parties over a 40-year relationship. So things that were considered were the set hours that they worked and that they generally didn't work for other people. And those were things that were heavily considered. So when it got to the High Court, they found that the relationship was actually between the partners in the partnership, and that partnership had contracted with the company. So this had actually overturned the previous full federal court decision that the drivers were employees. And similar to personal contracting, they said that where there's a contract in writing that contains pretty accurate and comprehensive statements about the rights and obligations of the parties, unless there's any of those exceptions that we discussed, the contract is pretty determinative. So assuming that it's not a sham and what's happening in practice isn't an employment relationship, there's no real need for the court to look beyond the contract to decide what's happening in practice. So the High Court found the drivers were independent contractors, and the court emphasised various aspects of the contract that kind of supported that conclusion. So the things that they considered were that the contracts were established with the partnerships, and so the drivers actually were able to obtain a lot of the tax benefits that came with that. So the unequal bargaining power was something that they did consider, which is interesting. They considered that had happened, and it was relevant to that contractual analysis, but not detrimental. And because the drivers provided and maintained their own vehicles, that was also very traditional of a contractor arrangement. So the majority in the High Court stated that the drivers' lengthy period of service and the fact that they earned their primary income from the company and didn't drive for other people were not a basis for disregarding the contractual relationship here. So in the time that they worked for ZG, they didn't actually really work for anyone else. But they had the option to. Within the contract, there was this ability to subcontract. There was this ability to work for others. They just chose not to. Okie doke, next point. So what does this all mean? I guess that's the reason we're discussing it. So the outcome of these cases and what they taught us in terms of how to structure a contractor's arrangement is pretty key. And there are a lot of takeaways from this. So the key takeaway, if nothing else from these cases, is that the terms of the contract will be pretty central to determining the nature of the relationship between a principal and an employer, and a contractor employee, that kind of distinction. And the subsequent conduct of the parties is pretty irrelevant. So in the past, you might have looked beyond the contract and looked at the substance and reality of the relationship. But what these new High Court decisions tell us is that we really only want to look at the contracts and the rights and obligations that contract creates. As we've discussed, this doesn't mean that you can just classify someone who is not a contractor as a contractor. So simply just saying in a contract that the worker is a contractor doesn't make it so. So you still need to assess the relationship and whether or not that kind of relationship is appropriate. But you look at it based on the terms of the contract. So what is pretty central to this analysis that we do is who controls the work. So who controls the work, how it's performed, when it's performed, and the extent to which a worker can be said to operate this independent enterprise. So in the past, we would have taken that checklist approach, the multi-factorial checklist approach. But in light of these High Court decisions, we don't really look at the practical reality. We really focus on the aspects of the relationship that are defined by the contract. And as an employer, you'd be asking yourself from the very beginning of that employment relationship, as the contract is being drafted, whether the worker that you're hiring, their work is so subordinate to your business that it's actually being performed as an employee of the business, rather than as part of that independent enterprise that worker is operating. Another thing to consider is, as insofar as practicable, the contract should really reflect that the contractor has that control over the work and how it's to be performed. Of course, there will be limits commercially on how much freedom a company is willing to provide their contractors. That's just the commercial reality of that situation. And so that's why it's very much a matter of a case-by-case basis analysis. But where it's possible, the contractor should have freedom to do the work in their own way. And it should be very much about the end result rather than controlling how and when they work. In terms of the post-contractual conduct, we would only now really look at it when it's falls into one of those exceptions that we ran through. So where it's alleged that the original contract is only partly expressed in writing, varied by subsequent agreement or conduct, affected by a estoppel or a sham. For whatever reason, if it's determined that the contract is invalid or unenforceable, that's when we start looking at the post-contractual conduct. Aside from those exceptions, what we can see from these court decisions is a shift back to the written contract as the sole method of characterizing the relationship, which hopefully provides a little bit of clarity for everyone now, because it's really about drafting well-drafted agreements. So in essence, what we're saying is that the status of the worker, in theory, should be locked at the time the contract is arranged. And what happens afterwards is a little bit irrelevant. So the contract helps us determine that what you've drafted to be a contractor will remain as a contractor for the life of the contract. My last point there that I can see here, that one's pretty important as well, because There are legislative schemes such as superannuation that deem common law contractors to be employees under certain circumstances. So, under certain circumstances and for certain purposes. So, for example, in superannuation, workers' comp, payroll tax, those are areas that have separate requirements as to whether they are an employee or a contractor for the purposes of those schemes. So the regulators that enforce these schemes might take a different view than what the High Court is saying here. So you may very well have a contractor for the purposes of employment law and payment entitlements and things like that, but you may have an employee for the purpose of superannuation, for example. So that's something to consider. So, as an example, I have listed a couple of the key characteristics of employees and contractors as a result of what the High Court has said and some things that we've kind of learnt along the way. So this is, of course, not exhaustive, it's just a couple of examples. So as an employee, you usually are unable to subcontract or delegate the work. So as an employee, I can't delegate my work to someone else. You have to be paid according to the time worked, usually. Businesses provide most of the equipment and tools required for the work. They are very much considered a part of the business, an extension of the business and a representative of the business. And they have very little control over the way that they work. It's very much at the discretion of the employer to decide how they work, what type of work they do, etc. A contractor, in contrast, a lot of the control element comes from the contractor themselves. So that's when they work, where they work, and how that work is performed. They are the expert in their industry, and you as a company would be hiring their services for their expertise and for that end result that you're looking to achieve. The contractor is usually performing the work as part of an independent enterprise rather than in a manner which is subordinate to the principal's business. So that's the point I made earlier, which is that they are running their own business. They're not necessarily running as an extension of the employer's business. They can subcontract or delegate their work. They are paid when the task is complete, usually, and they usually provide most of their own tools and equipment to get the job done because they're running their own business. So they should have the necessary equipment to be able to perform the services that they're providing to their clients. Which brings us to our key question. What should I include in a contractor's agreement? So this is absolutely not an exhaustive list. These are just a couple of examples of things that you should keep in the back of your mind when you are drafting a contractor's agreement. It's always a recommendation that, given how finicky all of this can be, that you get this drafted by an expert. But nonetheless, these are things that when we are drafting contractor's agreements that we keep in the back of our mind. So often we want to specify the work to be based on a particular outcome and not necessarily on the number of hours worked. So usually the contractor's agreement will specify that, for example, when this key performance, this key criteria is achieved, X amount gets paid. And this may be multiple different criteria that need to be fulfilled, and you may be paid on a different kind of payment schedule depending on the progress of the overall job that they've been hired to do. The contractor is usually not controlled in how they perform the job. That means that they're typically not required to comply with any sort of workplace policies that employees might need to follow. They're often able to have a little bit of discretion about how that work is performed. Depending on the type of job it is, there is the commercial reality that that kind of control is not always given to the contractor, but it's usual that they're able to control a majority of how that work is completed. The contractor has the right to delegate work to others, so they don't work just for your business, and they aren't usually the only person that's working for the business to perform the end result. The contractor usually has the right to negotiate a fee increase. Whether that's specified in the contract or not is a commercial decision, but they typically have the right to decide when they've exceeded the amount of time that they said that they're going to allocate to the work. And so they'd like a fee increase because it's really a commercial arrangement between two parties. The contractor should take insurance, take out the insurance. So they should have, indemnity insurance and all of those insurances that contractors should have. The contractor's payment should be contingent on the completion of a job and the supply of an invoice. So self-explanatory there. The contractor has the right to work for others. So they usually don't have a restraint, but again, that varies. It's a very case-by-case thing. Depending on how integral the work that they're performing is, you might need to put in a restraint or a confidentiality clause in there. But typically they have the ability to work not just for your business, but for other people as well to perform their services because they're running their own business. It's really at its core, it's about ensuring that the clauses that are drafted tend towards an employment relationship. So the obvious ones like leave, but also things like the right to control how the work is done, etc. All of those are removed, and instead the contract is more commercial, and the job is really based on outcomes. So if you have drafted a contract agreement and it's about labour that's over a set period of time, you may be at risk, and the agreement will need to be carefully worded to ensure that you're not overlapping with the employment provisions in the Fair Work Act that might classify the employee as the worker as an employee instead of a contractor. So what we suggest is that there is some value in considering some boilerplate clauses. So things that will demonstrate that the agreement is contained wholly in the written contract. So clauses that state that the contract reflects the entire arrangement between the parties and that variations of the contract must be in writing and that any waiver of the rights under the contract must be in writing. All of those kinds of boilerplate clauses that you might have seen before are things that typically should be included in a contractor's agreement. And what we're trying to do is ensure that businesses don't fall into one of those exceptions that I discussed earlier, which might result in the court looking beyond the terms of the contract itself to post-employment conduct, which makes things all the more tricky because the multi-factorial approach comes back into play. Okay, great. So that brings us to the end of the webinar today. I hope that you've found some value in the presentation today. As I mentioned, it was a pretty brief overview of a pretty complex area of law that's always evolving. So feel free to email me any questions at all, and I'd be more than happy to provide some assistance or to reply by email. Okay, great. Thanks so much, everyone.